Welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, David A. Simon, visiting assistant professor of law at the University of Kansas School of Law and project researcher at the Honkin School of Economics. In this installment of the podcast, which we have called Ex Cathedra, we will be taking a step back from actual legal articles to talk to senior scholars about scholarship. We were interested in how senior scholars develop their research agenda, who influenced them, and why. In particular, we wanted to know how junior scholars influenced the senior scholars and for what reasons. To discuss the topic today, my guest is Professor June Carbone. She is the inaugural holder of the Robina Chair in Law, Science, and Technology at the University of Minnesota Law School. She's an expert in family law, assisted reproduction, property, and law, medicine, and bioethics. She's taught courses in contracts, remedies, financial institutions, civil procedure, and feminist jurisprudence. I don't know if I've left anything out, but that's a lot. Professor Carbone, welcome to the show. Thanks for joining us.
Well, happy to be here.
So I wondered if you could start today by telling us a little bit about how your interest developed, whether that was in law school or afterwards, and how you became interested in family law and some of the topics you're researching today.
Well, let me start with family law. So I started teaching at George Mason University in Arlington, Virginia, a very long time ago. And it was a different era. So I was at the Justice Department. I had a friend who applied with them. She turned them down and said, "Why don't you talk to June?" So they called me up. I went and interviewed in February. I had a job offer in May. I never went to the meat market. I never interviewed anywhere else. I've switched schools since, but I sort of landed in legal academia through the things younger people do today. Now, I had written 2 articles, though, which was very unusual in that era. And my 2 articles were on things I had done in practice. One was more academic, the other was more a report on a case I worked on. That put me ahead of the game. But then I was teaching contracts. I knew nothing about contracts. And the family law professor said to me, how about doing a contract analysis of alimony? Back in the 80s, not much written about it. And I thought, oh, great, I can get my head around contracts by doing a contract analysis of alimony. The contract literature in the 80s was overwhelming. Family law, there were 3 major articles, and that was it. And it was like writing on a clean slate to do a different kind of scholarship than what was there in the family law literature at the time. So that's how I got started.
And what drew your interest to family law in particular? And specifically, were there any professors, senior people at Yale who reached out to you and said, hey, you might think about writing about this?
Nope. So first of all, again, it's a different era. It's pre-internet. The only person who I ever really worked closely with at Yale was Dan Freed on criminal justice reform. And indeed, one of the articles I'd written was on bail. And it was, I had written this article on bail when I was in law school that started, before the year 1000 and worked its way up to the present. And when I was at the Justice Department and got bored, which is after Reagan was elected, before he was sworn in, when people stopped suing the federal government. There was a very brief window, and I took it out of the paper, brushed it off, was on maternity leave, and started working on it again. And so if I had wanted to do criminal law, I would have gone back to Dan Freed. But, at that point in my life, I was very shy. The idea of talking to Yale professors would never have occurred to me. And although Dan Freed was incredibly supportive and really liked that paper, I did not talk to him about it when I was trying to get it published.
So it sounds like you didn't have very much support when you started out in your career. I wonder how, as you, especially in an era when I think fewer women were in the legal academy, how you maneuvered with more senior people, how you struck up conversations or debated articles or ideas with them, and how that shaped you going forward.
Yeah, and I do want to emphasize it was a different era. And I would say, as a woman breaking in, the secret is I was simply better qualified than the guys at every school I got hired at. I started at George Mason. I had already written pieces. The school was provisionally accredited, though very quickly got full ABA approval when I started. I had outproduced the young men on tenure track the day I started. And so I was never given a hard time about scholarship. After 4 years, my husband got a job in California. I got hired at Santa Clara. I got hired to start on tenure track. I was not yet tenured with people who had written less than I did. By the time I moved out there, I'd written 4 articles. I was being compared to people who had not started writing anything when they started. So my story is that I was simply ahead of the game. And again, if I were to see what people do today, it's scheming to get the best school you can get at when you start. Not me. I waltzed into places because, uh, you know, I needed a job. I happened to connect with people in the Bay Area. I got a job. I interviewed with 2 places, got one offer, didn't go through the meat market. Again, I was never part of the kind of planning to get into the academy we have today. So once I was in, I started writing. I sent things off. I got, and what I did try to do was to send drafts. I wrote an article on attorneys' fees because I worked on a case at the Justice Department that went to the Supreme Court, and I sent it to senior scholars I had never met and didn't know and asked for comments. Uh, that was productive. But I would say that it was years later that I really got to know the people in family law. Years after I'd been writing, had gotten tenure, was establishing myself. Then, as I began to go to conferences, I began to meet people. But that happened later. I think in today's world, it should be happening much later.
So it sounds like um, one of the things you did was reach out to senior people who might have an interest, an overlapping interest in something you were working on, said, "Hey, could you take a look?" And then how did the conversation go from there? Did you just take their comments and run with them, or did you develop relationships with them, working relationships with them that you could draw upon as you move forward?
So here's the thing that changed, and we should get, we should move into something closer to the modern era. So the first 3 or 4 articles I wrote, every single one was in a different field. I mean, I wrote about attorney's fees, I wrote about criminal law, I wrote about federally funded agencies, which is really about bankruptcy, but not formal bankruptcy. It was administrative. I mean, it was its own sui generis field. So it was like every article was a new subject. I don't recommend that. And then I started writing about family law. And once I started writing about family law, I got to know people. So at the time I started writing about family law, there were really about 3 or 4 people in the field I adored. Marianne Glendon, who moved to Harvard, Martha Feynman, who started at Wisconsin and moved to Columbia, Herman Hill Kay out at Berkeley, and Joan Krauskopf, who ended up at Mizzou. And over the years, I got to know each of them. Now, no, when you describe these people, these are 4 really different people who think really differently from each other. In that era, I would say it didn't matter so much. The world was less polarized politically and more was a question of women trying to get their foot in the door. But eventually, Martha Feynman had these series of the feminist legal theory workshops that she had at Columbia, and I started going to them in the 90s. And I got to know Martha, and I got to know her because I did a review of her book. I had absolutely no idea when I started writing who she was or anything about her except on the basis of what she had published. And I did a review of her book, and she loved it, partly because she felt I had captured something that her critics hadn't about where her work fit in feminism, not in family law, where I think where it fit in family law is fairly clear, but how it fit as feminist theory. And she was really pleased and started inviting me to the workshops. And That's basically in the 90s. And that's when I started getting to know the people in the field. And one of the bits of tensions at the time, by the way, was, so the first article we did at Divorce, which I did with Peg Brinig, who is my colleague at George Mason, um, was more about doctrine. And we noticed that people started paying more attention to us if we talked about other scholars instead of about cases. That was one of the things that kind of dawned on us. Uh, make the other scholars more prominent, and that was kind of more fun. So I started to do that, and by the time I was out at Santa Clara, and it was the '90s, I got money to host a conference, and then I got to invite the people I admired, Nancy Polligoff, for example, to come out. And when you start inviting people to things, they also notice you. So that's a good thing to do.
So one of the things that you mentioned, aside from inviting people to things, for the junior people that maybe don't have the budget or the position to invite people to conferences or workshops, you did mention going to conferences and being active by writing review articles. Are those things that you think junior scholars would benefit from today if they continue to do the things that you did when you were coming up?
Yes, and it's something that I find when I talk to junior people, both now and in the past, there's a tension. How much time should you spend going to conferences versus hunkering down and getting out the next law review article? And especially if for me, at once I had tenure, I spent a lot of time going to conferences where I was invited to write symposium pieces. And what I started doing was to write these pieces, which were solicited, and then fold them into my books. And I really stopped worrying about law review placements. But if you're trying to get tenure and you are concerned about sending out unsolicited articles, then going to conferences, especially if you're expected to write something new for the conference, can be a big distraction. Now, I find it helpful, but I don't really care about placement. I mean, I write a lot, and I'm producing several articles a year, and I'm able to produce more with a guaranteed placement. Than I shape the article for the placement rather than for, and what I want to say, rather than for, law review placement, uh, playing that game. So I think that's one of the questions you have to ask. How much time is it taking? Is this a help or distraction from what we view as your main work? And so, although I think getting to know people, the people in your field, really, really important. I mean, I will say senior people, we look at whether we know the person and then we decide whether to read it. So when I read things now, I read something that is directly on point to what I'm writing. I read things in my field that intrigue me or I feel I have to know. And I read things by people I like. So, there's a certain percentage of what I read because I know who the author is. And that's really important. For young people, I think getting a reputation as up and coming is something you often do by meeting people. But you also have to have written the work. I mean, I think the work you write is an entree. And if you haven't done the pieces you want to establish your reputation, getting that done is critical. And I do that first. But, half people we hire now have already done it before they get their first tenure track position.
You mentioned a few minutes ago that when you started out, you were sampling different areas of law, and each project was a totally new endeavor, and you were learning about a new area of law, and you did that for a while before you centered on family law and some of your other future work. I wonder how important you think it is for younger scholars to have a coherent picture of what their research is going to look like, especially given that when we conduct research, things change so frequently. Get interested in one topic, and then you decide, well, you go down a rabbit hole over here, and now you're interested in this other topic, and that's more on point to what you think is relevant. So you do that. So, how important do you think it is to have this package that you can show to other people, say, this is the kind of expert I'm going to be. This is where I'm going to be working in?
Well, I think writing, your first major piece, and by major I mean a significant law review article, is a ticket of entry to the conversations in the academy. So I think you have to write that first piece and get it done. And today, with a lot of programs to support junior people, you may want a cohort of people who are new, who are interested in the same things you are. And that's great fun. I mean, that just makes it much more fun to be in the academy. But after you get that first piece done, I think there's a question about what field you're in. So for me, it came actually after I got tenure. After I got tenure, I decided to write a book. And it took me 6 months just to get the hang of the different style of writing a book. It took about 5 years from the time of the glimmer of the idea to the time the book actually came out. But at the end of that 5 year period, I knew family law. I knew family law in a comprehensive way. And I found that after that period of doing the book, of doing the longer project, and this wasn't a textbook, it's called From Partners to Parents, the Second Revolution of Family Law. And it was my ideas on what was happening with family law and how it fit into a historical and economic and cultural perspective. But when I finished it, having talked about divorce and custody and parentage and, most of the major topics at the time, I really knew family law. And I found after that, if I wanted to write a new piece, I wasn't starting from scratch on research. I could have an idea and sit down and write it, and I knew what was out there. What I was finding the case is what the structure of the argument was going to be. And so my productivity increased very, very dramatically. I remember saying to a junior colleague at the time, I think about a piece a year. This is in that era, while on tenure track, is about right. But after you get tenure, you should be writing more, not less. 2 articles a year. And he looked shocked because, my junior colleague, who's very good, by the way, agonized over every word and every piece, and he couldn't imagine writing 2 pieces a year. And now I often write a half dozen in a year. Some of it is word processing, and the internet really helped. But some of it is, my first piece after I got a tenure track position, by the way, I wrote out by hand over the summer. I handed it, and we called them secretaries in those days, in August, and she got me back the typed draft of one article in November. So you could not write several articles a year in that era. Now you can. But it's not just word processing. It's also knowing the field. So this year I will have written 3 or 4 articles on the same subject. They will say different things, but the research for each of them, let's see, I wrote 2 symposium pieces. They are on the same topic. They have all the same footnotes, but they do say something different, and each is designed to address a topic that puts a different symposium. But the fact that I've done the research, which is also going to be in a book, makes it much, much faster. If you write a different article on if every article you write is on a different body of law, you have to do research on it.
I'd like to turn for a moment now to current scholarship in your field. What are some of the articles from junior people that draw your interest? And do they sustain it, and why?
Well, Jessica Clark is my hero. I tell people, so Jessica is my junior colleague who recently left Minnesota to Vanderbilt. And I was at a mentoring session for family law scholars, and I said, hey, for ambitious faculty at Minnesota, the buzzword is, what would Jessica do? And Jessica has mastered the art of the major law review article. She's placed pieces recently in both Harvard and Yale, but her minor placements are in NYU, Iowa. And she persuaded Bolt to do a 100-page law review article, which is extraordinary. And so I am absolutely inspired by Jessica whenever I think about what is it that makes a great law review article. and she's distilled it. And it's very much a combination of a topic that captures the interest of today's law students, distilled to a single idea across a number of different types of cases that makes you think differently about the topic. So let me give you an example. Her piece in Yale has the title Immutability, and it's about the question, how important is the concept of immutability, such as the immutability of sexual orientation, to protection, anti-discrimination protection under Title VII and other anti-discrimination laws. And of course, there's a whole debate within the field of sexual orientation about that topic. But the thing she does that is just brilliant is to take the idea and apply it to things like religion, obesity, criminal arrest records. So, on the one hand, these things are part of identity. If you have a criminal arrest record, or if you were obese, perhaps because of genetic factors, that may in fact be very hard to change. But it certainly isn't something you were born with. In some unalterable way, does it matter? And so she uses those different kinds of concepts of something that is part of an identity of who a person is today to challenge the traditional constructs of immutability and the concept of civil rights. And it's an absolutely original piece that gets you to think about an important topic in different ways. So Jessica is my absolute model for how to write a law review article.
Your comments suggest that one of the criteria for a good law review article is, of course, novelty, but in a way that's somewhat formulaic. And I wonder if you could say a little bit more about the different types of law review articles, aside from the kind that Jessica writes, that you find particularly interesting or helpful. For example, do you find articles that present empirical quantitative data about the number of divorces or the number of adoptive parents or whatever the statistic may be, do you find those add to the discussion in the same way, or are they more or less helpful?
Oh, well, I think of myself as a consumer of empirical work. So in the books I've done with Naomi Kahn, Red Families versus Blue Families, which got a lot of national attention, and Marriage Markets, How Inequality is Remaking the American Family. What we're doing is a synthesis of empirical work from a variety of disciplines, and then putting it into a legal context in a way that we hope will shed light on legal developments. So, for example, in Marriage Markets, which is interesting because sociologists and law professors tend to point to different parts of the book as of interest. But in Marriage Markets, the part sociologists responded to is we explained how even though the law of custody is the same for married and unmarried couples, women initiate the vast majority of divorces and breakups, and more so the poorer the couple. And if you're married and you want the divorce, then you bear the burden and expense of going to court, and the court is going to grant a divorce without giving the father at least visitation, if not full cut custodial rights. But if you're unmarried and you go to court, and you're unmarried rather, and there's a breakup, typically the woman kicks the man out. And if he wants custodial rights, he has to go to court. He has to bear the expense and the inconvenience. And it's and if he has an arrest record or if he has anything in his background that's unsavory, he may not want to go to court. He may not want to go near the courthouse. He may simply not be able to afford it. And so what you see is this vast discrepancy in custody outcomes between married and unmarried couples that have very little to do with the formal law and that had not been in the interdisciplinary literature. The divorce lawyers know this, but it's not really in the literature in a way that anybody paid attention to before he wrote it. Now, Naomi and I are very proud of doing that because what it involves is we think of ourselves as consumers of the empirical literature. Our empirical contributions tend to be doing things like reading census reports. In red families versus blue families, we had put together how the country is changing in terms of family form and how the change in family form maps onto the vote. But we had put a lot of that together before the demographers had created a composite that identified that nationally. By the time the book came out, we could just cite other people whose empirical work was better than ours. But we started with some empirical ideas other people weren't exploring. We took the empirical literature that was out there, we wove it into a narrative that explained legal developments. And that explanation was novel. So I view myself as incredibly influenced by empirical work that's out there. And, I'm doing a conference this fall in honor of Peg Brinig, with whom who taught me family law at George Mason years and years ago. And what I'm going to say about Peg's work in particular is that as somebody who's a lawyer first and then got a PhD in economics, the empirical questions she asks are different from the empirical questions economists ask in looking at the same data sets. And so her work is quite original in a way that's often not fully appreciated by other lawyers or by economists unless you know both fields and you say, oh, yeah, the questions she's looking at are really interesting because they're different questions. And so I have really appreciated folks who are doing empirical work that get at questions important to legal developments, which are often not the same questions that sociologists or economists are asking.
Do you think there's a danger for younger scholars in particular when they stick their toe in the empirical water, swirl it around a bit, and maybe try to do what you've done and synthesize existing literature and then apply it to law? Do you think there are any dangers there for junior faculty?
Oh, they're huge dangers. The first thing is there are two different fields with two different definitions of what is methodological rigor. And I can tell you, I have been at any number of law professor discussions where you read something that is difficult to conduct in really original empirical study, and law professors go, oh, it proves something we already knew, or it doesn't say anything terribly profound. And the originality is really in pulling together the material and pulling it together in a way no one's done before. So sometimes the hardest part is simply the collection of the data, and then, how good is your regression analysis? But most law professors glaze over at any discussion. I can tell you I do, of a regression analysis. Even if I understand its importance, I want to know what's the answer. Does it support or undercut the argument I want to make? The methodological rigor of the study itself. I read them like somebody who is putting on a case or about to conduct a cross-examination to support where I want to go. And I'm quite happy to take it apart if it doesn't. But it's just a whole different way of reading empirical work. And so if you're coming before a faculty that knows very little about it, it's interesting, we had somebody on our faculty who came up for tenure not too long ago, who I think was doing some interesting empirical work at the intersection of three different fields. And, his first couple of years on tenure track, the faculty was fairly negative. And over time, there was growing appreciation, and he successfully got tenure. But part of it was an education process. The people in the substantive legal field felt the work was simplistic. The people who had PhDs in non-legal fields felt the methodology of the empirical work was simplistic. The people who knew the third field, which had to do with the practice area, knew very little about the specifics in the area he was working in. And over time, what happened in the successful tenure vote was an education of the faculty that putting together these three different literatures had never been done before. And that the innovation in the work had to be assessed in light of the fact that the methodology was original, the subject area wasn't terribly well explored in academic work, and the conclusions to be drawn from it were of a different nature from what you expect from a traditional law review article. Well, it took a while to educate the faculty as to what the contribution underlying that work was. It's incredibly risky to do that.
If we could switch switch gears for a second here, and I'd like to ask about what sorts of things do you find turn you off, are unhelpful, that younger scholars tend to be doing when they're writing or presenting that you wish you could tell them but can't tell them to their face?
Well, in family law, let's talk about family law. So, on the one hand, right now I'm writing a book about the intersection between women, the economy, and changes in the family. Okay, and the younger scholars I'm totally jazzed about. Mostly people not yet in the academy who are coming out of traditional law firms, and they have such a generationally different view of law and economics, corporate law, securities law, that kind of stuff. And then I meet the younger family law people, and there's just a total generational difference on attitudes about marriage, about you know, not just the gender part, which I'm aware of, but the single parent families, non-marital births, that whole thing, and a whole new set of vocabulary coming along with it. So, the thing that I would say to both groups that's hard for both groups is the generational mindsets are just different. And I find on the corporate law and economics area, I love the junior people. They're saying stuff that's music to my ears. I think it's so much more exciting than anybody my age. In family law, I don't feel the same way, maybe because it's my field. And the question is why? And I've tried to be self-critical about that. So young people coming in do have a different view of the world. The world they're seeing is different. That generational difference in viewpoints is going to play out politically. It always does. That's not new. But on the family, the piece of it that my co-author Naomi Khan and I have been resisting is that the young people want to show they're trendy by being totally skeptical about marriage. But underlying the difference between marriage and non-marriage are functional differences. So when you talk about people who are making a very conscious decision to live together and not get married, who often are my junior colleagues, they just view marriage as an old fuddy-duddy kind of thing. And those of us who study this, who study it, try hard to see it from the viewpoint of not just what are my attitudes as somebody who's about to have her 40th wedding anniversary, who actually believe in marriage, but rather about what's going on around us. And so one of the things going on with marriage is a class divide. And the reasons why a 22-year-old woman living in a relatively poor community who is living with and has the father of her children living with her, the reason they don't get married is really kind of different from the reasons why some of my junior colleagues choose to live with somebody and not get married. They're not worried about whether or not he's going to get arrested. They're not worried about whether his credit card bills are going to result in her assets being seized. And so there's a difference between, I think, a generational change in perspective, where, on transgender issues, I really am deferring to my younger colleagues. I think the whole question is what gender means. There's a lot of exciting work being done, and those of us who are older are trying to get used to it. I mean, it's a new vocabulary, it's a different way of thinking. Some of it is really original, and I'm very excited by it. But I find some of the assumptions about marriage are rooted in privilege. So the very people who like talking about, who think it is trendy to be married, marriage is this old fuddy-duddy kind of thing, I think often are missing the class dimension of this and the different meanings institutions have when you take class and race into account. So on the one hand, they're really, really eager to talk about class and race. But on the other hand, many of us find that we fear that in an effort to be enlightened based on their own experiences, they are missing a dimension out there that they ought to be troubled by and would if they were more embedded in different communities. And so I think that's the hardest thing. And I find it hard. When I do interdisciplinary work, I'm pretty good at figuring out what law professors want to hear. It's taken me a while to figure out what non-law professors want to hear. And I think that generational difference is there in almost every field as well. It's not just that we have different viewpoints generationally. It is also that what people mean by the same vocabulary is often different.
If I can paraphrase you, it sounds like what you're saying is don't get lost in your own experience. Try not to make your own anecdote apply to the entire field you're examining, and pay attention to either the empirical work or the data that's coming out or just other people before you forge a path in whatever field you're moving in.
Exactly. And, family law, let's face it, we all have families. We all have some degree of angst about our families. And so trying to distinguish between living through your own experiences versus generalizing. For example, on LGBT issues, I've been writing recently about the convergence between the law that governs, say, step-parents versus unmarried same-sex couples. And they overlap, but the feel of the two bodies of doctrine are different. And now the same-sex couples can marry. I think you're going to see a growing reconciliation of the doctrines. But what it means in Kentucky and what it means in California and what it means in Minnesota and what it means in Michigan are going to give you four different answers. That's really hard to capture.
Yeah, I think that's really great advice. And I'd just like to thank you for all the advice that you've given us so far and for your time. And we really enjoyed having you on the show. We hope you'll come back.
Oh, I'd be happy to.
Okay, great.
And thank you for doing this.
Of course.
Right, cue recorder. That's it. Off we go. Hello everyone, my name is John Shuttleworth. I live on Godthorpe Drive with my charming second wife, Mary.
That doesn't rhyme, John.
We have two children. Their names are Darren and Karen, and collectively we're known as the Shuttleworths. Now in case you've just switched on, my name is John. Hello there. And if you said to me, are we a happy family? I'd say fairly. Now there's your rhyme, Mary and Fairly, you see. We live in a semi next door to Vera and Penny. If you're passing by, say hi to the Shuttleworths. Tupperware.